Got me carry on as normal.
Right. Good morning, everybody. We've all come out under the slightly worrying Storm Eustace, not Storm Eunice this time, I think, that's on its way, and I think it's going to be further south from where we are in Stafford. But please be careful when you drive home again. In terms of today's meeting, the Countryside Rights of Way panel, we'll start with apologies, please.
Yeah, good morning, Chairman. I've received apologies from Councillor Abrahams.
Thank you. And item number 2, declarations of interest. Have we any declarations of interest? No? No. Okay. So we'll now move on to item 3, which is the minutes of the last meeting. Moved? Okay, we're all happy with the minutes. Thank you. And item number 4, and I will read this, the Highways Act 1980, section 119, proposed diversion of public footpaths, Quornford, number 29, brackets part, and number 34, brackets part, at Glede Trail, Quornford. And is this, who's taking this?
I am, Chair.
Oh, thank you. Thank you.
Sorry from a distance.
Would you like to start?
Yes, thank you, Chair. If I can turn you to page 11 of your bundle, it's got a plan relating to the diversion proposal. That shows that the routes to be extinguished are shown by a solid black line, A, B, C, and B to D. In particular, A, B, C runs immediately in front of the property known as Glede Tail, right in front of the front door and the front windows, across their garden area. And then B to D is a very steep section of path linking into down to the valley bottom there. The application has been made by the owners of Glede Tail in their own interests, effectively, in the interests of privacy and security, really, to make their garden area exactly usable without the public walking through it, essentially. So the proposal is to move the path round onto the route shown by the broken black line. So that's CFD and then an AED. This is a very steep, rugged area within the Peak District. There are spectacular views from all around the area, to be quite honest. And the path, those routes have been selected to provide better gradients, certainly than B to D, which is very steep, and to follow natural lines in the landscape to get round to point D. Between points F and C, there is a proposal to zigzag the path down the slope, and that's to provide suitable gradients on that point. So in terms of legislative criteria, the proposal is made in the interest of the landowner on that, because it'll move it away from their property, but the diversion still all remains in land in their ownership. In terms of convenience, etc., the alternative routes in terms of gradients and everything overall are very reasonable, and it should be noted, I think, that in anybody who's using these paths will be suitably or should be suitably equipped for walking in effectively extreme conditions, because it is a very remote location. In fact, you can hardly get there by car, never mind on foot. We have undertaken consultations with all the usual bodies. There's one objection to the proposal from the Peak and Northern Footpath Society, Their objection relates to enjoyment of the route in so much of loss of views compared between the two routes. Now, as I say, this is to be quite honest, the whole area has spectacular views wherever you happen to be to be stood. So whilst there may be a loss of certain views, it certainly doesn't detract overall, in our view, from the enjoyment of the route. Because if you look to the left of the page, where you've got footpath 29 running westwards from point D, you've got the whole valley opening up down there, and it is they're all spectacular views. I don't think there's any doubts there. So on the basis of, whilst we've got an objection on that, we believe the criteria of the legislation can still be met, and therefore we're recommending that an order be made.
Thank you for that. Could I just reiterate two things? First of all, there's been no objections from the local parish council, and secondly, that both the old route and the new route are owned by the same people.
Yes, that's correct. Yes, no objections from the parish council, and everything's the whole proposals are all within the same land ownership.
Paul.
Thank you for the report. Did those who objected to the new route and the grounds they did say it wasn't conducive perhaps to enjoyable walking, did they make any suggestions for an alternative route that would have assisted that?
No, we didn't. We didn't have any alternative suggestions. As I say, it was essentially a matter of loss of view that was the basis of the objection, rather than anything to do with the immediate terrain. It's purely the picturesque nature of the views that they're objecting on.
I think, as you rightly said, though, wherever you go in the Peak District, you get a beautiful view. So footpath 29 will just perhaps replace the one slightly lost view with perhaps an even better view. So thank you very much.
Thank you.
So proposed that moved by David Smith, seconded by Paul. I'm in favour. Yeah, unanimous. Robin, thank you for that.
Thank you, Chair.
Could we now move on to item number 5, which again is Highway Act 1980 extinction, section 118 and 119, proposed concurrent diversion and extinguishment orders, public footpath, Tamworth 81C and 83 at Wilnecote Quarry, Tamworth. Is this you again, Robin?
It is, Chair. Yeah.
Thank you.
Yes. Thank you. If I can turn you again to the plan relating to this, we have plans on pages 25 and 27. If we start on page 25, by way of background, this is a set of proposals to seek to resolve a very long-standing problem whereby sections of these footpaths have historically been quarried away, so the routes are simply not available in any shape or form. That being the case, that's not in itself a consideration that you should consider when assessing the proposal against the legislation. The paths should be considered as if they are open and available. But they were quarried many years ago. There's been subsequent changes in land ownership, so the current landowners have effectively inherited this problem. They are aware that it needs to be resolved and have been working for some considerable time with the council to come up with a set of proposals to seek to resolve the problem. The proposal on page 25 is the diversion element of the concurrent proposals, and that seeks to close the path running A, B and round to C that's shown by the solid line, and to create a new path running A to C on the line of the broken black line. All of that land is within the ownership of the quarry company. It's all in the same ownership, Well, obviously the broken black line, the proposed new route is outside the actual area of quarrying. It follows a relatively level, as far as is possible, route through a wooded area to link back to the path. That in itself, in terms of consultation on this element of the proposal, this has been met broadly with support from all parties. There's no real issues as far as the diversion element concerns. But if you just note on page 25 the location of point B, and then turn to page 27, we can see point B is replicated on that plan as well. In order to enable the diversion to take place, we need to deal with the section of footpath that's shown B to D on the plan on page 27. And the proposal is to extinguish that section of path, because if we don't extinguish it, it would have to somehow link back into the diversion proposal that you've looked at. Otherwise, it would leave a cul-de-sac path, which would be unacceptable. So the package, it is an all or nothing package, to be quite honest. The diversion and extinguishment have to either be approved in their entirety or rejected in their entirety. In terms of consideration of this, this section for extinguishment is considered. It's not necessary for public use. It's been diverted a number of times over the years, and hedging lane and the other the continuation of footpath, the diverted footpath, we think provide a suitable alternative that's actually being used. Now, in terms, as I mentioned, Chair, a bit earlier, this again is something that has to be considered as if the path's fully open and available. But at the moment, it would run through what would be a live quarry site. And also where you see the area between the red buildings, that is a working industrial yard. So it's not particularly a nice environment, but once it went into the quarry site, due to mines and quarries legislation, if that path were to be open and available as far as was reasonably practical, it would be a fenced corridor, potentially with fences 1.8 metres high either side, and that corridor wouldn't necessarily be any wider than 1.2 metres at its maximum, because that we either don't have a width in the definitive statement, or the 1.2 metre width has been created by previous diversions. And so there's no reason why the landowners would give any extra land. That it would be a 1.2 metre corridor without any escape routes or anything like that. So in considering the potential for future use, which is the sort of second element of the test effectively on extinguishment, it would be a very unpleasant path, and we don't think it would attract a great deal of use, other than perhaps initially people trying to make a point of walking it purely as principle. This is the element that's attracted objections to the proposal, and most of those objections are predominantly on the principle of the path should have never been obstructed, it should have never been quarried away, and there's some suggestion that this would be part of a longer used route, but having questioned and corresponded with various objectors that we've got, they don't appear to. There's been no significant use of the route prior to it being quarried, so it is, and in principle, yes, they may wish to use it rather than any historic basis of a huge amount of use. As I say, it actually links just back to Hedging Lane, and using the diversion route up onto Hedging Lane and then down to point B, there's good footways and everything. So we think that's probably about as best we're going to get with this situation. If the diversion doesn't go ahead, whilst again this isn't a material consideration in the decision, just so that to clarify, as I suspect the question would be answered, if the question doesn't go ahead, then chances are these paths will simply remain obstructed for a considerable period of time in the future, until the whole quarry site is restored. And whilst that will happen eventually, there's certainly no immediate plans for any restoration. There's no real practical enforcement available to the authority. In terms of reinstatement would be impossible. The only other line would be to enter into prosecutions of the company who now own it, which could well attract fines and the like. But it's unlikely to actually resolve the situation in the whole. So this is the one opportunity perhaps to find a resolve and at least provide the diversion alternative. So on taking all matters into account, we do feel that the criteria of the legislation can be met, and therefore we're recommending that these orders be made.
Thank you. Do we have any questions or thoughts from the members? Paul?
I think it's a logical decision to make. I'm sorry. It's a danger to go into a quarry with a footpath there. Okay, people might think the quarry shouldn't be there, but the quarry is there. We're not going to move the quarry, divert the quarry elsewhere, are we? So the logical thing, as a person who's walked for the Lake District, Scotland, Wales, the Peak District for many, many years, I've got to say I'm in favour of it, and I will propose it.
So unanimous, and we'll take the officer's recommendation and agree the changes. Thank you very much for that, and we'll now move on to item number 6, please, which is the Wildlife and Country Act 1981. And this is an application for the addition of an alleged public right-of-way from Ivetsey Road to Belhurst Lane, Wheaton Aston. And I think there's two issues here. Here is the right-of-way and what type of right-of-way it is. So, are you taking this? Oh, sorry. So apologies. It's okay. I'm having to crane my neck behind to see what's going on there. I feel I've got this weight over my shoulder, which is Mick. He really is keeping his eye on me from behind. David, please.
Yes, thank you, Mr. Chairman and members of the panel. Just to confirm that we've had no representations from the local member on this application. Well, it's an interesting application for Wheaton Aston. It's interesting because it's been built upon both historical and user evidence, and each appears to support the other. Before we progress further, I should perhaps point out that the original applicant who submitted the claim in 2006 has since passed away, and that this fact is most respectfully acknowledged by your officers. Sincere thanks should be accorded to the representatives of the original applicant for enabling the parish council to succeed them. For absolute clarity, Lapley, Stretton and Wheaton Aston Parish Council have been the applicant since 2019. I will move straight to the recommendation, which is that your officers believe that there is indeed sufficient evidence to show that a public bridleway subsists on the balance of probabilities between points A to B on the plan attached to Appendix B to this report. And if you turn to the plan, you will see those points marked between Ivetsey Road and Belhurst Lane. It should be noted that in the original application there was a slight discrepancy in that the Form 1 did not specify the status of the route to be claimed, although the Form 2 did indicate that this was a claim for a public bridleway. Notwithstanding, in cases like this, officers are able to determine which status is the most likely based on the evidence before them. In support of the application, we have both historical and user evidence, more particularly 21 user evidence forms, which you will see at Appendix C, and 6 historical documents that you will see at Appendix E. Further historical evidence was submitted by the Parish Council, which can be found at Appendix G. The applicant identified several potential landowners, although the track itself was confirmed as being unregistered by Her Majesty's Land Registry. The adjacent and adjoining land was found to be the ownership of several landowners, the owner of the property known as Seven Oaks being the primary landowner, owning the greater portion of the land either side of the alleged right-of-way. None of the then current landowners returned an owner response form in 2006. A former landowner, Major A.M. Yates, did return an owner response form, visible at Appendix F, with a detailed plan and photographs. As the application was based on both user evidence and historical evidence, the probity of each has to be assessed on its own merits. Section 31 of the Highways Act 1980 and the Rights of Way Act 1932 provide the necessary legislative framework for a right-of-way to become a public highway through usage. The user evidence does appear to satisfy these legal requirements in that although the application was made in 2006, when the route had become obstructed, an earlier relevant period running from 1984 to 2004 could be identified. In 2004, there was also very clear evidence of a challenge to use by the installation of sheep wire or netting at either end of the route. And I think I've said in the report at around point 34 that although this was soon removed and only noted by a minority of users, it still cannot be ignored. This therefore ratifies the fact that a challenge was made and that the relevant 20-year period must therefore be calculated retrospectively from this date. Your officers should also point out that the phrase concerted effort noted in the user evidence to remove this wire is of course suggestive of force, meaning that the 20-year period could not extend forwards from 2004 unless use was resumed unchallenged for another 20 years. A total of 8 users testified to using the route throughout the relevant 20-year period, running from 1984 to 2004, or approximately 38% of the total 21 user evidence forms received, in excess of a third. One user had accessed the route much earlier, between 1938 and 41, and although this falls outside of the relevant period, it does demonstrate that the public had used the route for a protracted period of time. The route appears to have been largely used for pleasure purposes and by users on either foot or on horseback, with a predilection for seasonal use, although it is clear that the use ranged from once or twice per week to weekends and then down to once or twice per month. All 8 of the users stated that they had used the route on foot, while 4 of these, 50%, stated they used the route on horseback. Clearly this shows that both horses and their riders were using the route regularly and in sufficient numbers. This is further supported by references throughout the evidence to horses and carts being used along the way. As you will note at point 52 of the report, your officers had to determine whether there were any higher rights on the route arising from the user evidence. There was a very minor reference to motor vehicles on the route, although it was of such a limited nature that nothing could be gleaned from it. The reference to a tractor and a motor of some undefined description is therefore incidental. Had the use of carriages or carts been more consistently shown in the evidence, and more particularly in the usage during the relevant 20-year period, then a case for a restricted byway could have been made out. However, the evidence was again somewhat incidental and not significant enough to turn the case. Notwithstanding, on scrutiny of the evidence, it became clear that there was enough equine use to support a bridleway claim as outlined in points 49 to 51 of the report. There is a perfect summation of the usage of the route at point 59 of the report, whereby Susan Saunders states that it is just a useful little lane for walking the dog and riding the horse. It is important to note that none of the user evidence forms received, including those covering the relevant 20-year period, testified to there being a gate or stile at any point along the route. Clearly, except in the sheet wire of 2004, the route was never obstructed, nor does there appear to have been any prohibitive signage erected at any time. That said, there does appear to have been a considerable amount of obstruction on the route from February 2006, which appears to have triggered the application later in that year. Jumping to point 77 of the report, there is a detailed exposition relating to these obstructions. These obstructions appear to have been put in place by the then new owners of the adjoining property, Seven Oaks, and included branches, grass cuttings and garden waste. More significantly, a tonnage of earth and a deep ditch at the Ibetsey Road end were also noted, although neither appears to have completely blocked the route. It should be reiterated that these 2006 obstructions, if that's what they were, fall outside of the relevant 20-year period and so cannot defeat the claim. Turning to the width of the route, we have a stated range of between 4 and 14 feet, although there seems to be a predilection in the evidence for a width of between 7 and 8 feet. It is, however, somewhat immaterial, as the evidence is weighted towards a bridleway, which could include, as its maximum width, the full extent of the land between the bounds. It can also be said that there is no dispute about the line of the route. It is clearly demarcated on the associated plans, which are all consistent, and it is further supported by the historical evidence. It is a simple and straight route that leaves no room for ambiguity. Consistency has been a hallmark of the application. There are several detailed comments made at points 79, 81 and 82 of the report whereby users have testified to their own use of the way. There is even the intimation that it had been used for between 2 and 3 centuries, and the evidence of W. Wesley, a parish councillor for over 17 years, chair of the council for 10 years, states that the route was an ancient right-of-way. Again, this does not add any probity to the application, but it does support the general perception noted throughout the evidence. C. Blakemore, who supplied user evidence, stated that the lane was even used for training young horses and formed part of a small circular route, adding that the lane is officially owned by no one, and that all local residents had used it at some point during the past 40 years. The fact that the lane is unregistered does not automatically mean that nobody owns it. Landowners may hold deeds to land without registering it until, of course, it changes hands. In this case, however, no landowner can be shown to exist. A probable reason for this is given in the historical evidence, which further supports its status as a highway. Taking all of the user evidence together, therefore, we find that the scales tip very markedly in favour of a public bridleway subsisting along the alleged route. The references to horses recur throughout the evidence, and it is significant that there is no record of a challenge. Turning to the landowner response forms, we find that none of the adjacent landowners supplied a completed form. However, an earlier landowner did respond, Major Yates, who had been a former owner of Sevenoaks and the field that adjoins the lane. Interestingly, his ownership coincided with the full extent of the relevant period, running from 1984 to 2006. Within his landowner response form, he indicated that he had installed a fence at each end of the track. No date was given for this, although given the references in the user evidence forms, it can only have been the sheet wire referred to in 2004. Major Yates went on to state that he had never given anyone permission to use the route and that no statutory declarations had been made in respect of it, the latter being documentation that a landowner can lodge with a local authority to effectively defeat a future claim. Curiously, the respondent did testify to seeing both walkers and horse riders using the route, adding further probity to the contention that a bridleway does indeed subsist. Major Yates stated that he had only stopped and turned back one user on the route, a Wendy Arthur, who also supplied a user evidence form. Although, as can be seen in the report point at 112, the quantifying statement does not suggest that this was a challenge to use as such. It merely reveals that Major Yates informed Miss Arthur that she was damaging the hedges by continually driving through them. Notwithstanding, the sheet wire fence is already noted as a definite challenge in 2004. Major Yates, as a former owner of Sevenoaks, goes on to state that the route is not shown on Ordnance Survey maps, although as members will be aware, OS maps and plans offer very little in the way of legal probity. It appears that Major Yates' solicitor advised him to fence off the track at both ends, which he did in 2004, which effectively brought the use of the route into question, as we have seen. Interestingly, the evidence provided by Mr. Yates actually appears to support that provided in the user evidence forms, which is a somewhat unusual, not curious, position given their differing perspectives. Turning to the historical evidence supplied by both the applicant and the parish council, we find an interesting group of documents which again adds further substance to the user evidence. Firstly, the tithe map of 1839 to 40 shows the lane distinctly marked and separate to the numbered holdings, which is highly suggestive that the route was part of the highway. Although the associated transcript is missing, the plan is clear and the lane is shown to be commensurate with and linked to other roads. More significantly, we have a map of roads dated 1856, a few years after the tithe map, and this clearly shows the lane between points R and Y. It appears in the accompanying text as Birkenshaw Lane and is accurately described for the avoidance of doubt as lying between Bellhurst Lane and Ibetsey Road. This map of roads was completed for the surveyors of highways, and its detail and content present it as a document of very good supporting evidence. When you start to see alleged routes named in Victorian primary sources bearing reference to the surveyor of highways, then it cannot be discounted, particularly when backed up by a near-contemporary tithe map. A series of other maps were also evidence in support of the claim and do clearly show the route, although these appear to be details from various Ordnance Survey maps, and as such their probity is limited. That said, they do record physical features on the ground, suggesting that the route was at least visible and therefore potentially in use when the plans were drawn. Further evidence from the parish council indicated that they very strongly supported the application, stating that they believed there was a strong local evidence to show that this has been a public highway and that it should be formally dedicated and opened up again for public use. Turning to the 6 pieces of evidence provided by Deborah Bate, clerk to the parish council, we find that the 1938 OS map does indeed depict the physical feature of the route as it appeared upon the ground. This is repeated on a larger scale OS plan of 1962 and named as Grass Road, being exactly the same route shown on the 1856 map of roads as Birkenshaw Lane. Accepting the difference in the terms, road and lane, it appears that in common parlance the route was more usually known as Birkenshaw Lane. The map of roads is also submitted by Deborah Bate as a copy of the one supplied by the original applicant, which is stated already is good supporting evidence. Anything bearing reference to the surveyor of highways has to be viewed with a degree of credibility and therefore probity. There was an email communication from the Diocese of Lichfield confirming the land was not owned by the church, which although noted neither supports or refutes the application. Deborah Bate notes an anomaly in the record by highlighting that the lane was not part of the maintainable highway and as was previously believed, although nothing turns on this. Lastly, the land registry title for Sevenoaks shows this now to be the primary landowner on both sides of the lane and that the title does not include the lane itself, confirmatory proof of what we had previously been assumed, or we previously believed. Following the circulation of the draft report, a number of responses were received. The primary landowners at Sevenoaks responded stating that they objected to the application and that the route was overgrown and impassable, meaning that not even a walker, let alone a horse, would be able to access it. As members will be aware, the physical accessibility or even presence of a route on the ground has no bearing on its legal status and has to be discounted. They also contend that their solicitor had carried out the necessary searches when they bought the property and that it was not a public footpath or bridleway in 2006. They indicate that they would not have bought the property if this had been the case. As members will be aware, the route would not have been shown on the definitive map or statement in 2006. It would only have shown up as a charge after the application had been submitted. They also contend that the previous owner of the field told them he owned the track and that nobody ever used it. Your officers aver that the previous owner may have been genuinely mistaken on this point, supported by its later and in fact total absence from the land registry record. They further contend that the track was not used for a combined total of 37 years, the period covered by Major Yates' residency and their subsequent ownership. However, as we have already seen, there is strong user evidence covering the entire period of Major Yates' ownership, and he himself confirms he witnessed both people and horses using it. Much is made of the impassability of the route, but again I can do no better than to reiterate the earlier point that this has no bearing on the legal existence or non-existence of the route. There is a contention that there would be health and safety concerns where the track joins Evertsey Road on a somewhat precarious bend where there is a 60 mph speed limit. Again, as members will doubtless know, these are not concerns that can be taken into account at this tribunal of fact. The same can be said for the 2 big concrete water pipes, which are highlighted as an obstruction on the route and the water ditch, where it is suggested that a substantial bridge would be needed to allow equestrian access. The question of a bridleway gate at either end has also been raised. Again, any questions relating to bridleway gates or bridges are not matters for this panel. In the event that the claim succeeded, then the relevant officers would advise on these concerns. Regarding their solicitor's advice on that they own the track, it has to be said that where no other evidence exists, this may be true. However, each case is different, and as always, it depends. In this case, we have strong evidence that the route was and is part of the highway. The surveyors of highways and the tithe map cannot be ignored. In any event, the ownership of the lane is largely immaterial. Irrespective of the historical evidence, we have strong user evidence attesting to its use as a public bridleway. Even if the land was in their ownership, it could not defeat the user evidence and, in turn, the claim. There are also a number of photographs in the addendum for which we thank the landowner, although again none of these add anything of legal probity to the claim, and more particularly do not defeat it. A second adjoining landowner, Lorraine Tonks, also responded, stating that they too may not have purchased the property had they known the track was a public right-of-way. Concern was raised for the wildlife and nesting birds, as well as the fact that the route was overgrown and impassable. The perceived danger of the 60 mile per hour road was again referred to, as was the large ditch at the Ibetsey Road end. Again, none of these points have any legal bearing on the existence of the route and have to be discounted. All of these responses to the draft report are, of course, given very fully in the addendum. Taking the totality of the evidence together, your officers feel that it is sufficient on the balance of probabilities to satisfy the test and that a bridleway does exist and subsists. We have a named route, Birkenshaw Lane, clearly identified on a Survey of Highways record and on a tithe map, supported by a series of Ordnance Survey maps and its absence from the Land Registry. We have user evidence testifying to unchallenged use throughout the 20-year relevant period with a predilection for equine use. This use has been as of right and without force, secrecy or permission. There is no evidence of any challenge from any landowner during the relevant period, and the route was only brought into question in 2004. It is therefore the opinion of your officers that the County Council should make a modification order to add the right-of-way, which is the subject of this claim, with the status of a public bridleway to the definitive map and statement of public rights-of-way for the district of South Staffordshire. It is further recommended that there should be recorded a minimum width of 3 metres and a maximum width of the full extent of the lane to meet the bounds. Lastly, I would like to thank the applicant, landowners and the legal representatives for their courtesy throughout this process. Thank you, Mr. Chairman. Happy to take any questions.
Thank you for the report. I don't think I've ever heard one here myself that's been so well documented from both sides that everyone sort of says it's a lane, and the only things that seem to be sort of against it are technical, which aren't actually impinging on this case. David.
Thank you, Chairman. Chairman, I think that there's something which comes out in the report which doesn't give me any concern about us approving it, but I suppose gives me a slight concern that someone bought land without doing a proper search on any conditions. I would have thought that if you did due checks and probity on the purchase that you were making, it would have come to light the evidence which we have produced, which shows an absolute clear existence of a road which goes through the fields. The current condition of it, as the officers reported, is irrelevant. I mean, if you block up each end of it, it's fairly obvious it isn't going to get used and it'll fall into disrepair. I can't see that we have any alternative but to support the officer's recommendation, and I'm happy to propose.
Thank you. In terms of the land searches, that's really, I would understand something for the landowner to take up with their solicitor. It's nothing to do with this case and not relevant. I think the other thing I would say as chairman is the ownership of this land. I would suggest that the parish council have a look at land registry and see what's what. But that again is not one for this committee. It's just my observation as chairman. I'll pass on to Paul.
Chair, thank you. Just first to echo your comments about the report. It was one of the most detailed but unbiased reports I've heard for many, many years. We have to look at this as balance of probabilities, but I think it's gone far past balance probabilities. It seems to have gone almost into the remit of without reasonable doubt. The evidence is so stacked to one side. If you look at when the major decides he's going to put the fencing up, it's when he comes to sell the land. As if he can sell the land to somebody and say, well, there's fences up here, it's not a bridleway. And if we go back to all the evidences we've all learned from our training, as David has rightly said and you've said, there's no objections we can use which are planning objections or contrary to the 53 Act or any other Act really. So I would gladly second what Councillor Smith has said and just echo all the points that have been made.
Bring Mick in. Is there anything on the legal side you want to mention on this one? I think it's cut and dried.
The only thing I was going to say, Chair, is that you've already stolen my thunder to a certain extent, is that the question of ownership in some respects with regard to public highways is moot. The public highway takes precedence over any ownership rights. There is a rule in law which is called ad meum file rule, which means that if you're a landowner on either side of a track, in the absence of any other evidence, the presumption is in law that you own up to the midpoint. Obviously, if you own both sides of the track, then you own the track to all intents and purposes. The reason why it not be registered can be several over the intervening years. As David rightly points out, it waits for transfer, but also whether or not it's included in the deeds. That might be historical, because at one point the lane may have been used by diverse landowners and nobody was very keen to claim ownership, because that would mean they'd have to do the maintenance. That could be one answer. Nobody knows. That's lost in the mists of time. The other point that Councillor Smith makes is that there is an option to do additional searches when you purchase property. If you don't tick the option, you don't get the additional search. One of those additional searches is to see if there's an application for a route to be added to the definitive map. We do inform our land charges when we get applications. Those are lodged with them as a local land charge, because we recognise that people who want to buy land in the vicinity may have a concern if there is a proposed public right of way there, or that it could be a blight upon their land. But that also depends on how far the search was. If it was just for a particular piece of land, it may well not have revealed it. It's not relevant for this panel, and it doesn't come to be taken into account. I'm just providing that as a point of information. Thank you, Chair.
Thank you, Mick. I found it interesting, and I'm sure the rest of the panel did as well. So, in terms of the business in front of us, we've got a recommendation from the officer to proceed with granting this application. We've got a proposal from David Smith, seconded from Paul Snape. Just Jill and myself, I'm in favour. So that's unanimous then. And can I thank you, David, and Mick and Robin, if you're still around, for your very informative presentations. Thank you. And we will move on now, please, to exclusion of the public. Have we got any items? We have. So I'll read out this the paragraph which is legally binding. That the public be excluded from the meeting for the following items of business which involve the likely disclosure of exempt information as defined in the paragraphs of Part 1 of Schedule 12A, brackets, as amended, of the Local Government Act 1972, indicated below. Thank you. We'll just wait now to be taken offline.